Well, this is a part of what Mr. Adekunle Ojo, the former second vice president of the NBA, is here to discuss. Thank you for coming on this morning. Good to see you again.
Good morning. Happy to be with you this morning.
Well, this happens to be, the latest or the highest profile case.
Right.
And it's gone this way. And perhaps not surprisingly why there's been so many reactions to this. Right. As there will always be to different cases when you talk about tackling grafts. But having listened to the report and followed through with the story and how it's gone, were you in any way surprised that, so after all of that hoopla, no case to answer?
Well, it's quite unfortunate that this is where we are, especially, not really because no case submission was upheld, but considering what we all went through, because we were all following it. It's like almost every Nigerian was affected one way or the other. Yes, we want to read if truly this man, if truly he didn't declare, because these are the salient issues. Did he declare his asset as at when he was going into office and when he was leaving? Did he acquire more? All those properties that were listed. I mean, look, these are bare facts that basically for some of us should be enough to justify him being placed in the witness box to answer a few questions. But unfortunately, the law is the law. And as of today, we already have a judgment in place. And perhaps the best that could be done by the other side is to appeal that judgment. But to all of us back home here, we felt that, look, some of these facts are just too bare for anybody to cover up. You can't even use some of these legal technicalities as far as Nigerians are concerned, because the questions are, I mean, look, you may say yes, not credible enough, he has not said what he's supposed to say, but then, because at this level, what is expected is whether a prima facie case has been established against him or otherwise, not really go into the sufficiency of whether the case is strong enough or it's not strong enough and all whatnot. If a man came out and to say, look, I'm aware that certain money were transferred from GTB to so place. If you go into whether the document was lost or was not lost, and that now formed a basis for you to say, look, it's not going to be able to prove it. You are saying it's not going to be able to prove it, but then to a good number of us, a prima facie case is already, that's the truth. If a man says, yes, certain money were given for a particular purpose and it was diverted, it was supposed to be a loan and it was transferred to some other places where the documents, we don't have it presently, it got burnt and all whatnot, but then let the other man come out, did you really do it? But that's my angle to it.
So you think that this case was dismissed based on technicalities?
Well, for me, if you need to really look at the whole. But then if I pick one or 2 points, then I will tell you that, look, it shouldn't really have been, the no case submission should not have been upheld. But it's already upheld. What can we do about it? Let the other side look at it strictly. There are certain, yes, if you look at the contradictions, yes, a judge can come up and say, okay, look, for a no case submission to be upheld, if there are contradictions, then it has to be upheld. If the elements of the offense were not proved, it could be upheld. Like hearsay evidence, it could be, yeah. But then if somebody comes around to say, I facilitated the transfer of money, I'm picking that point because for me, that looks like, yes, this man is saying, I facilitated the transfer of that money. For us to now say, look, where is the documentary evidence? But the man said so. I did it. At that point in time, for me, a prima facie case is already being laid, and it really warrants the other side being called to question to come and answer, yes, this man said he did this for you.
Does this take away from the anti-grafts agenda that we're pursuing in this country?
Well, basically, if you look at this, and again, if you look at what happened at the Court of Appeal, the case of Urubebe again, he was convicted by the Code of Conduct Tribunal. He's been let off by the Court of Appeal, and if you look at basically, for me, yes, it has. Basically, it has dampened the morale an average Nigerian, because we are beginning to believe that, look, perhaps at the end of the day you won't find anything against anyone. And people, there are insinuations there, which basically, as a lawyer, I won't subscribe to some of them, but then basically we need to be a bit careful about how we run our affairs in this country. Why going to court if at the end of the day, if at the end of the day we are not likely to get anything out of it? And basically it's on the front burner of the present regime that, look, we really want to check corruption in the country. And again, to worsen the situation, some of us actually believe that one of the greatest weapons or the agency or a tribunal that could be used effectively to curb corruption in this country is the Code of Conduct Bureau and the Code of Conduct Tribunal. And how do I mean? Because basically, you come into office, we have found out that the bulk of our money is being siphoned outside, it's being siphoned to places that it shouldn't be. It's the conduit pipe through which our money goes off and through which poverty is imposed on us compulsorily is through the public service. And public service, there is a routine on how money goes out. So we felt that, look, if you come into office, you can imagine a public officer, a level 10 officer who is a proud owner of houses in Victoria Island, in Ikeja, and in so many other places. And at the end of the day, nobody seems to be asking him, calling him to question. So we felt that the CCB, the Code of Conduct Bureau, should be able to liberate Nigeria fairly from some of these problems, and by extension, the Code of Conduct Tribunal. And you see, for a good number of these tribunals, justice should matter more than some of the technicalities that we are talking about.
But you know, before now, we saw the stance, we saw the body language, the way the CCT went about it, and it did, at least some people thought that they were not going to hold any prisoners, they were going to go full throttle on the law. But at the same time, the rule of law in this country presumes or says that, well, you have to prove your cases beyond reasonable doubt. Yeah. The fact that one individual said it, if you can't prove it, isn't that part of the reasons why those inconsistencies?
Well, at the level of Dr. Saraki's discharge now, it cannot be said that a case was not proved beyond reasonable doubt, or the case was proved beyond reasonable doubt. All that we needed at that level was a prima facie case. You can't even go into some opinions. You can't even go into evaluation, some deep evaluation of evidence. The best that could be done is bearing what this man has said. Where do we go from here?